All right, it looks to me like we have everyone in the room, so I'll get started. Good morning. I'm Hearing Officer Nicole Kinsey with the Administrative Hearings Office of the State Water Resources Control Board. And before we get started, I just wanted to ask whether we have a court reporter present. I wanted to verify. I know the County of San Joaquin mentioned they may be bringing in a court reporter, and I wanted to make sure we have those technical issues worked out if we do have one present. Do we have a court reporter on the line?
Yes, Council, I'm here. My name's Veronica Guerrero. I'm your court reporter today.
Good morning, Ms. Guerrero.
Good morning.
Let me know what capabilities that you need. Do you need access to a Zoom recording? Do we need to authorize you for that? Or do you have everything you need just by calling in?
I think I have everything. I think I should be fine.
Okay, great. Thank you very much. And please let me know as we go through this proceeding, if you need us to slow down, you need names, any of those normal things, please let us know.
Perfect. Thank you.
Here. All right, I'll get started. So this is a status conference for the pending application of the County of San Joaquin, application 29657, for a permit to appropriate water from the South Fork American River by diversion at the Freeport Regional Water Authority facility, which is located on the Sacramento River. This status conference is being held in accordance with the Notice of Status Conference dated January 5th, 2021. This status conference is being conducted by Zoom web conference and is also being broadcast live on the AHO YouTube channel. Both the audio and video are being recorded, and we will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage, and as we just noted, we have a court reporter present with us as well. And I think you can probably contact Ms. Guerrero if you would like to obtain access to that court reporting service. If at any time during this proceeding you're experiencing technical difficulties trying to communicate with us, please send an email to the AHO at the AHO email inbox, which is, I don't have it in front of me, admin HRG office at waterboards.ca.gov. We'll be monitoring that email inbox, so we'll know if you're having those difficulties, so please let us know. Assisting me today are several staff of the Administrative Hearings Office, this Nicole Mullen, Amy Blanc, Megan Nyes, Skylar Anderson, and Kyle Woolridge. And I do want to note that we received, the County of San Joaquin, we received your presentation, and we'll get to that as we move along in the proceeding today, but we do have that, and Ms. Mullen is prepared to screen share and make that available for everyone to see when we get to that point in the proceeding. So let's go ahead and move over to roll call, move to appearances. To do that, I'm going to identify each of the entities that filed NOIs. And as I do, if you're representing that entity, please unmute your microphone and state your name. In general, as we proceed, please keep your microphone muted except when you're speaking, so that we can minimize the background noise and unnecessary interruptions. And if possible, I see most of you. Thank you very much. Please enable your camera when you're speaking so that we can all see each other. I appreciate that. So let's go ahead and get started. I'm going to start with the applicant, San Joaquin County.
Good morning, Barbara Brenner, outside special counsel on behalf of San Joaquin County, and there's several other members of the county here present, Matt Zadar, Karen Berg, Fritz Buckman, and from my office, Carrie Fuller, who will also be able to introduce themselves.
Would you like to introduce yourselves now, or we can move forward? I was just going to go entity by entity. So you're here. I know we know you're present. Thank you. Good morning.
Deputy County Counsel with the Office of County Counsel for San Joaquin County.
Great. Thank you. Good morning.
Matt Zadar, Water Resource Manager for San Joaquin County.
Thank you. Good morning.
Fritz Buckman, Deputy Public Works Director for San Joaquin County.
Thank you. Good morning.
Good morning, Carrie Fuller from Barbara Brenner's office for San Joaquin County.
Good morning. Thank you very much. I appreciate that. I think, you know, if we're going to be working together for some time, then it's nice to know you and see faces. Moving on to the city of Stockton.
Yes, good morning. Mel Lytle, Assistant Director for the Municipal Utilities District, City of Stockton.
Thank you. Good morning. North San Joaquin Water Conservation District.
Good morning, Jennifer Spalletta, General Counsel for North San Joaquin Water Conservation District.
Thank you very much. Good morning. Stockton East Water District.
Good morning, Jeannie Zalezi, General Counsel for Stockton East Water District.
Good morning. Thank you. And I have listed together, I believe you're co-represented, but correct me if I'm wrong, State Water Contractors and the Kern County Water Agency.
Yeah, good morning. Joe Byrne on behalf of both those entities, and I'll let my colleague Kara Johnson introduce herself.
Yeah, Kara Johnson, Best and Krieger, also on behalf of those two entities.
Thank you. Good morning, both of you. Westlands Water District.
Good morning, Tommy Sagatelian on behalf of Westlands Water District. You had John Rubin originally doing the notice of appearance on behalf of Westlands. I'm the Deputy General Counsel appearing on behalf of Westlands today.
Thank you very much. Good morning. Contra Costa Water District.
Doug Cody, General Counsel, Contra Costa Water District.
Thank you. Good morning. San Luis and Delta Mendota Water Authority.
Good morning, Rebecca Aykroyd on behalf of San Luis and Delta Mendota Water Authority.
Thank you. Good morning.
Morning.
Glen Calusa Irrigation District.
Yeah, good morning, Aaron Ferguson on behalf of Glen Calusa Irrigation District, and I'm also here on behalf of Sacramento County Water Agency. And we also have Forrest Williams on behalf of Sacramento County Water Agency as well.
Great, thank you very much. I see those and I have them next to each other in my notes, so that's perfect. You check the next two boxes. Thank you very much.
Great.
So we have Sacramento County, Glen Calusa, and now moving on to El Dorado Water Agency, please.
Good morning, Ms. Kinsey. Kevin O'Brien representing El Dorado Water Agency.
Good morning, thank you. El Dorado Irrigation District.
Good morning, Brian Polson. I'm General Counsel at El Dorado Irrigation District.
Thank you. Good morning. Freeport Regional Water Authority.
Good morning, Janice Snyder, Counsel for Freeport Regional Water Authority.
Thank you. Good morning. San Juan Water District. We can circle back, but I believe in our NOIs, Mr. Paul Helliker from San Juan Water District. I will come back to that at the end, see if he joins us in the meantime. Sacramento Municipal Utility District.
Good morning, this is Joe Schofield. I'm SMUD's Deputy General Counsel.
Thank you, good morning. I have next the City of Folsom, City of Roseville, Sacramento Suburban Water District, and Woodland Davis Clean Water Agency.
Good morning, this is Holly Jacobson on behalf of all four.
Great, thank you, good morning. California Sport Fishing Protection Alliance.
Good morning, Chris Schutz for the California Sport Fishing Protection Alliance.
Thank you, good morning. Friends of the River.
Ronald Stork, Friends of the River.
Good morning. And now, last but not least, I'm moving to our agencies here. The Bureau of Reclamation. Do we have?
Yes,
Ms.
sorry.
Holm? Great.
But Lisa Holm with the Bureau of Reclamation.
Wonderful, thanks, good morning. The California Department of Water Resources.
Good morning, this is Eric Soderlin on behalf of the Department of Water Resources.
Good morning. And the California Department of Fish and Wildlife.
Good morning, this is Nancy Murray on behalf of the California Department of Fish and Wildlife. I believe we also have Bridget Gibbons from our region office on.
Yeah, good morning. I'm Bridget Gibbons on behalf of California Department of Fish and Wildlife.
Great, thank you. Good morning. Just circling back, just to make sure, San Juan Water District. Mr. Helliker. Okay. Did I miss any participants in my roll call? Is anyone on the line who would like to introduce themselves, or did I miss anyone who would like to be participating today?
This is Forrest Williams from Sacramento County Water Agency. I just didn't say anything. Eric just introduced me.
Great, thank you. I'm sorry. I moved along pretty quickly there. Thank you. Good morning. And I will just note, Mr. Helliker or anyone from the San Juan Water District, if you're currently listening on the YouTube live webcast, please use the Zoom meeting link to join us, and just let me know if you join us and that you're present. So first of all, we'll get going to the substance. I mean, bear with me today. We do have, I think it's more than 21 of us, certainly including myself. So we'll try to move through this in an orderly fashion. But I wanted to thank you all for submitting your notices of intent to appear and setting up our current service list. I realized when we started this proceeding, we had a fairly old, stale service list. So I appreciate that update. That I think will make it easier for all of us going forward. We can communicate with each other more effectively and via email. All of you should have received the updated service list yesterday by email from the AHO. If you didn't, we can provide that to you. Or if you have any corrections, if there were errors. I realized we had some errors in the email addresses for the some of the San Joaquin County staff, and I apologize for that. And we've made that correction. So that should be fixed going forward. The purpose of this status conference today is to clarify the status of San Joaquin County's pending application 29657 and to discuss the next procedural steps either by the board or by the applicant to process that application. And I wanted to clarify, just starting off, that the outcome of the status conference today is not going to be a substantive decision or a proposed order as to whether the board should or should not cancel the application or continue the process. What I'm trying to pin down today and determine at this stage is whether and when to schedule a hearing, what the scope of that hearing should be if we do have a hearing, or whether the AHO should take some other kind of action. And that's what we're here to discuss today. I did raise several questions in the notice of status conference for us to address. I received status conference statements from most of you responding to those issues, which I appreciate. I've read those status conference statements carefully, so they were very helpful. So today there's no need to repeat that information that you've included in your status conference statement unless there's some particular issue that you think needs to be emphasized or we need to revisit. I'm going to go ahead and get started. I'd like to move through generally in the order of those items listed in the notice of status conference that you laid out and addressed in your status conference statement. I'm actually going to skip number 1, if I may, because I think it's clear from the county's submittal that the county does wish to pursue its application. We are going to, I know you submitted your slide presentation. I do want to get to that. I was thinking it would be most appropriate when we get to item, I believe it's item 3 on our agenda today. And I know it may cover item 1, and you may have covered more items than just item 3, but I thought that would be an appropriate time, if that's okay with you, to hear that presentation, which I look forward to because I think it'll be helpful for me. So I'm going to begin with item 2. I'm sorry, I didn't mean to interrupt. Was there a comment from Ms. Brenner or the county on that? Does that work for you?
Yeah, I was just indicating that that's fine. We can do it whenever you're ready.
Great, thank you very much. I'm going to begin with item 2, which is whether each of the protestants want to maintain its protest to application 29657. The division initially received 15 protests to the application. Of the protestants, I believe the following, and I'm just clarifying all of this for the record, I believe the following did not file NOIs and are not represented today. If you believe otherwise, please correct me. This is California Salmon and Steelhead Association, Save the American River, and Defenders of Wildlife. Of those who are represented today, the following indicated in their status conference statements that they want to maintain their protest to the application. So there's no need to reiterate here, but I'm going to make the list so we all know. Freeport Regional Water Authority, Sacramento County Water Agency, Friends of the River, California Department of Fish and Wildlife, CSPA, Glen Colusa Irrigation District, San Luis and Delta Mendota Water Authority, State Water Contractors, Westlands Water District, Kern County Water Agency, SMUD, and Contra Costa Water District. Now there's also I realize the issue of the El Dorado Water and Power Authority, which filed a protest to application 29657, but I understand from the status conference statements, the authority has since been dissolved. And the former member agencies, El Dorado Water Agency and El Dorado Irrigation District have indicated their intent to maintain the protest filed by El Dorado Water and Power Authority. And I'm gonna, if there are any corrections, we'll get to this, but let's move along. So that leaves the Bureau of Reclamation and the Department of Water Resources as protestants who have not yet indicated for the record an intent to maintain their protest to application 29657. So I just wanted to move through those two very quickly so we can get that on the record. Ms. Holm, would you please clarify for me whether the Bureau wants to maintain its protest to application 29657?
The Bureau does want to maintain its protest to the said application.
Great, thank you very much. And Mr. Soderlin, does DWR want to maintain its protest to application 29657?
Yes, and I apologize. I thought I sent that statement with the NOI, but if it didn't come through, then I do want to reiterate the department maintains its protest.
Thank you very much. And we'll check our files and make sure I didn't miss anything, which occasionally happens. And then there were a few participants today who did not file protest, had not in the past filed protest to the application and did not file status conference statements. So I just wanted to clarify so that I understand, if you would please state for the record whether your interest in the application is generally speaking in support, generally in opposition, or neither. If you can just explain the interest of the entity in the application. I have in my notes, I have Ms. Zalezi representing Stockton East Water District. Would you, I'm wondering whether Stockton East is generally in support, in opposition, or at this time?
Stockton East Water District is in full support of the application.
Wonderful, thank you so much. And then I was also going to ask the same of San Juan Water District, but I don't believe we have a representative with us today, unless I'm in error. Thank you, okay. And Ms. Jacobson, on behalf of the City of Folsom, City of Roseville, Sacramento Suburban Water District, and Woodland Davis Clean Water Agency.
Hi, yes. Actually, we are in protest. We would request to reopen the protest period. I believe the application was filed sometime in 1990, so it predates the issues that impact these clients.
Thank you. Thank you for that clarification. I appreciate that. So I've gone through my notes and my list on the clarifying where we are with the protests and the participants today in terms of opposition or support. Are there any comments from anyone in addition on the issue of protests to the application? Great. Thank you. Moving on. So moving to item 3 in our list of issues, I asked the county for an update on the status of action items that are necessary for the board to continue to process its application, including the development of appropriate environmental documentation, the right to use the Freeport diversion facility for diversions, and resolution of other elements of the various protests that were filed. I have read your status conference statement, and I believe you submitted a PowerPoint presentation, which we have ready. So I think this would be a good time to move to that presentation. Ms. Mullen from my staff, will you please share your screen, pull up the presentation and share your screen, and we will hand over the microphone to Ms. Brenner. And Ms. Brenner, I believe you're on mute.
Thanks.
Thank you.
Thank you. And we've gone through the introduction, which was the purpose of this first slide, of all the members of the San Joaquin County that are here to support the application. So we can move on to the third slide, actually. Yes, to that. We just wanted to remind everybody the history and how we got here, as outlined in our submittal in much more detail, and quickly walk through the main points of these decisions. So if you go to the next slide, Bulletin 11, in 1954, you can go ahead. Thank you. Department of Water Resources actually identified the need for the county, and one of the areas for that supply was the American River. And of course, back then it was as much as 303,000 acre feet annually. That idea was first introduced by DWR again in 1954. We go through the time period in 1956. They were denied the permanent right to the McCollum River, again pointing to the American River in Decision 858. Decision 893 in 1958 denied the county application for rights on the American at the request of the Bureau of Reclamation, again indicating that they would supply the water to the county. 1960, the county actually developed a service contract with the Bureau of Reclamation. Unfortunately, the Bureau failed to execute that agreement or series of agreements. Next slide, please. In 1970, we have Decision 1356 that again reiterates the county would be assured of access to the American River under the Watershed Protection Act. It's important to keep that in mind. We're relying on the Watershed Protection Act in this application, which does not have a time frame. This right is available to the county without limitation on when the time to support that application. So we don't feel that this is a type of application that be subject to random cutoff or random timelines. Decision 1422 in 1973, the Bureau testified that the county area north of Calaveras River would be served by the Folsom South Canal. And that right was limited in reliance on the county being able to get water from the American River and the Folsom South Canal. We all know the Folsom South Canal has never been constructed. The county then in 1990 proceeded to go out on its own and no longer rely on the Bureau and the promises being made there, and filed application 29657. Again, filed under the Watershed Protection Act in order to protect itself and maintain that status and its ability to actually get water from the American River as promised and directed by the State Water Board, Department of Water Resources, Bureau of Reclamation. Next slide, please. And then we have Water Rights Order 2008 that revokes the Reclamation's Auburn Dam permit. This eliminated the county any way for the Bureau to serve the county. And in that decision, the State Water Board affirmed, and we quote here, we affirm that there is a public interest in supporting the efforts of San Joaquin County to obtain adequate water supplies. We submit that that should continue, and the State Water Board should definitely continue to support, and it's in the public interest to support San Joaquin's efforts in this regard. As a result of the last hearing before the State Water Board, the county filed its fourth amended application in 2014. This is significant in the sense that it shifted the county's point of diversion to the Freeport Diversion Facility and added the groundwater storage. At this time, the county has now developed its resources and realized that the best way to utilize what has now become a wet water, only available during heavy water season and limited to approximately 50 to 60,000 acre feet per annum based on the latest modeling efforts. This is the direction that they are headed. And again, it's more expensive, less water, less intrusive to all other water users, in that it's a wet diversion season. Next slide, please. With that, I'm going to move it on to Matt, who's going to talk about what has been happening over the last 10 years approximately. Matt?
Sorry, I was muted there. I see a bunch of familiar faces, people that I've had the pleasure of working for over a number of years. You can tell who those are by the ones that are still smiling, going, oh no, I get to work with them again. Good to see you all. Lot has been happening, and I think Premier is the feasibility study of the Freeport project that really looked at and provided a very detailed water availability analysis, which I know is an important criteria, documenting that there was water available in that December to June time period without big reoperations requirements for Folsom or any fisheries effects or impacts. A very good piece of engineering work and hydrologic analysis. It documented the Freeport pipeline capacity that was available, given the nature of the Sacramento County membership and entitlement to that and their negotiated agreements with East Bay Mud. It documented all the physical facilities that we would need to actually convey the water and distribute it within the county for direct recharge or in lieu uses in that time period, December to June. It looked at the alternatives evaluation. It took all of those pieces, configured them into a range of alternatives, and then did the constraints analysis looking at legal, political, environmental, economic, and other technical engineering constraints to come up with at that time, a preliminary preferred alternative that then went through a preliminary environmental review, as did all the alternatives. So it really laid the foundations for doing a subsequent CEQA or NEPA document. There was a plan for CEQA and NEPA and a permitting strategy documented in that report. Let's move to the next slide, please. I bring this up because there's a whole lot of history. Starting in the groundwater management and planning, starting in, oops, let me bring up my version of this because I've got a bunch of notes on it. 1 second, please. Starting way back in 2000, the context and history is really key here in terms of local actions. In this local shifting and evolving local policy environment that we've all lived in the last couple of years. Just to reiterate what has occurred and what set up this planning process, the Bureau and the State Board decisions forced us off of Mokwalamy to the American River. We were held hostage for a long time to the CBP and the Bureau's intention to fully subscribe that project, which again never happened. Ultimately denied our access to the American River water and to other local rivers on the Stanislaus to make us participate in the CBP elements of Auburn and Folsom South Canal. We were told the American River visa FESC would be the cheaper source and were denied a water right, an official filing of the water right that could have been happening in the 50s to the American River based on those directions and promises, again, from DWR, the State Board, and the Bureau. The State Board order in 2008 did happen in this time period. Again, averred our the public interest aspects of our filing. In all of our planning, the American River was viewed as water available for recharge. And that's kind of the contemporary term when we're looking at integrated conjunctive use and flood-mar types of operations for water banking and storage and for addressing our critical overdraft. It's important to note that there has been very activist groundwater planning in the county starting in 2004 when we were subscribing and supporting AB 3030 and SB 1938 types of groundwater management plans, and a lot of our districts put those plans together. With the change in statutes and availability of a lot of resources, Prop 50, 84, 1, all of those, we developed in 2007 an integrated regional water management plan that brought together all of our stakeholders, all of our interests in water districts to prepare that plan, which documented this, we called it ICUP, the Integrated Conjunctive Use Program, at which point a draft programmatic EIR was prepared saying, here's what we're going to do, how we're going to do things, where we're going to go, and fully anticipated subsequent actions tearing off of that document to support conjunctive use and use of water from the Mokwalamy, the American, and our other available sources on the Calaveras and Stanislaus. The final EIR was then adopted in 2011, and all of this work was happening under what was called the Groundwater Basin Authority, which was a JPA formed of stakeholders to be able to take action and move forward, seek grants, build projects, et cetera, et cetera. very key to our resolution of our protest on our application, which was protested by East Bay Mud, who's not here, you'll note. We signed a funding agreement to partner on the DREAM project, excuse me, which was a demonstration recharge, extraction, and groundwater aquifer management program to show that it was very viable to take water from whatever important source, put it in the ground, store it, come up with the agreements that would allow extraction and use by local partners or interregional partners like East Bay Mud. Part of that funding agreement later evolved into a protest dismissal agreement with East Bay Mud on the Mokelumne River filing, which we have maintained and have full intention of maintaining. And under that protest to one of their filings, East Bay, in a settlement, East Bay Mud agreed to withdraw their protest to our American River application and support negotiations with the Freeport Regional Water Authority in Sac County. Obviously, East Bay Mud is a big partner in that, and recognize all the constraints and the agreements necessary to utilize that. But they backed off and said, okay, we won't protest your American River, and we'll try to help you with Freeport and Sac County. There's been limited progress on that part of things. But that all happened in 2014, again, when we released that phase 1 Freeport element with the preliminary environmental review. Key factors to success in any of these things is conjunctive uses. Do you have the water? Do you have the partnerships? Do you have the money? Well, the American River water is really important for our conjunctive use and overcoming critical overdrafts. And whether it was us or say the state board in the future under finding our GSP inadequate and putting us on probation, state board would be looking at all of these waters available for recharge as well, and need to decide how we were going to address the critical overdraft. And hopefully, besides cutting back on our agricultural economies, constraining our economic development, it would be to develop these supplies, which is certainly our intention. Moving into the later timeframes, when the Groundwater Authority was disbanded and the Groundwater Basin Authority and the Groundwater Authority was formed to expand the participation in the local planning and to comply with SGMA. And SGMA was a big part of that changing policy environment that really threw us a curveball and sopped up a lot of local and state resource to prepare the groundwater sustainability plan, which we submitted in January 2020, consistent with the SGMA requirements for critically overdrafted basins, to put in a plan on how they would achieve sustainability by 2040. In our minds, we obviously would think that American River was water available for recharge to help us solve that problem, especially given the prior decisions of the state board. The support we've received from DWR in helping to develop our plans. Thank you very much, DWR. And moving through the development of that GSP by our, count them, 16 GSAs, which are stakeholders and participants in that Joint Powers Authority, to look at how will we manage this basin-wide to achieve those sustainability goals well documented in our GSP. As part of that development, a number of things happened that were consistent with the schedule and item 8 defined in the 4th amended permit. We prepared a very detailed basin characterization of the hydrology and water quality, which was one of those things on the schedule. And we developed the East San Joaquin integrated water flow model using DWR. And with the support of DWR, again, thank you very much, with a stressed basins grant, we developed that IWFM model for the East San Joaquin and have run and calibrated it and developed some future scenarios. So it's a tool ready and available to assess what are the benefits from the potential projects contained in our GSP and evaluate any of the impacts that might occur through our development or even our lack of development of additional water supplies. So the tool is there to evaluate the water budgets, to help assess impacts and to find benefits to be achieved consistent with the necessary funding agreements. And like I said, water, partnerships, funding. American River is a big part of that water that we need to overcome critical overdraft. I think we've demonstrated the potential for partnerships, both regionally within our basin with all of our water districts, cities, and everybody that's members to the GWA, and our partnership with East Bay Mud to look at interregional opportunities to address this critical overdraft and provide opportunities to our partners like East Bay Mud so we can help them meet dry year supplies. And I think there's a lot of opportunities for us to support not only regional, interregional, but a much broader area of benefit, say statewide, where we are participants more actively in the greater stage, and state water contractors and other interests may be able to participate and partner with us rather than resist what we're trying to do to achieve, say, modern groundwater management practices and implement projects that would allow us to do that. So we'll never deny partnerships and conversations with people wanting to help. We'd be happy to further address and resolve any outstanding protests. And we look forward to those kinds of conversations. Lastly, again, I mentioned the adoption of the GSP. We have also updated the IRWMP to be consistent with state law. And again, to qualify for grant fundings and demonstrate our local partnerships. What has been lacking and it has been the challenges, same with districts throughout the state, is raising funds and getting support through the Prop 218 or Prop 26 or whatever mechanisms we need to identify funding. And thank God SGMA now gives us potential alternative revenue generation schemes that would let us and help us define the projects that are going to help us overcome the critical overdraft, put all of the water available for recharge from American, Calaveras, McCollum, Stanislaus to beneficial use, get it in the ground and move forward to achieve sustainability. We've chosen to look at projects rather than say cutbacks like some of our peers and neighbors to the south are having to make, because we have physical solutions. And that I use that as a very specific water rights term. We have physical solutions that we can implement to overcome this overdraft. Part of which would be the use of this American River water, possibly Freeport. Heck, we'd love to look at other opportunities to more cheaply and cost effectively move water into this county as originally promised, whether that's Folsom South Canal or other potential points of diversion that we may have access to. And we're looking at all of those. We're just saying, please don't take this important right that had been committed to us under area of origin, watershed of origin status away from us and limit our opportunities to solve this critical overdraft. Moving right along, next slide, please. Again, just reiterating on a couple of those details, that phase 8, table 6 schedule or table 8 schedule said you need a basin characterization. Check that off the box, it's done. Prepare a groundwater model, surface water model. Check that off the box, it's done. That demonstrates pretty significant progress on two very important aspects that were manifest in the fourth amended application. Next slide, please. Now, other related things in terms of protest settlement. I mentioned that 2013 DREAM funding agreement. The progress we've made on that, we're under construction on pipelines and pertinences to put water in the McCollum Aqueduct so East Bay Mud can take the water out of the groundwater basin where it's been stored. It's operated for storage under multiple years. 2018, we put water in the ground. We're going to fire up pumps and demonstrate the viability of this important aspect of our local management, groundwater banking, storage, and the types of arrangements that can happen under our county's water export permit, which allows for this type of operations. And we did issue a permit in 2017 to East Bay Mud then to be able to operate and export water that they have stored in our basin under the management of local entities, demonstrating strong local control consistent with SGMA. And we're moving forward with that. Mentioned the 2000 protest settlement agreement with East Bay Mud that allowed for the DREAM project, removed their protests in the American River, and supported our negotiations, which have not progressed with FREWA and Sac County Water Agency. Mentioned the permit. Our groundwater projects and priorities are defined in the GSP, demonstrating commitments to moving forward. And again, our need for water from all the available sources. And our goal is to develop the next most cost-effective physical solution. American River right now is still more expensive than some of those solutions, but we don't want that taken off the table as part of the solution set that we may need to implement over the next 20 years to 2040, consistent with the GSP. We need it to be able to solve this problem of critical overdraft. And again, we don't feel like it's sunsetted because of the protections that we have. And in this regard, we started to try to resolve our protests with El Dorado County Water Agency and EID. And there was communications after the Fourth Amendment permit about that. And heck, we're here not just to defend our American River water rights filing under watershed protection, but watershed protection status in general, which is what EID did a wonderful job making our case, as did El Dorado County Water Agency in their filing. Watershed protection is a critical component of their future, and we agree with them, and our future. And we hope that we can get them to agree with us, and we could come to some settlement acknowledging seniority, priority, volume, availability, and I think all of that is able to be addressed. In terms of other things, I mentioned the GWA priority and projects. Example, North San Joaquin, one of our peers here, has worked really hard on being able to build the facilities or rehab the facilities for their north system and their south system, seeking grants and support and local funding. We could put American River water in that diversion, those pipelines, get them to beneficial use, get the water in the ground, look at direct recharge, in lieu recharge, and now we love this idea of flood mar and potential spreading of water to achieve sustainability. And with that, I'm pretty much done. Said a mouthful, I suppose. And I think the next question, that since the presentation is up there, I'd ask for the next slide, and I'll turn it back over to Barb. Our simple answer to the question is no.
No. Yeah.
Ms. Berner, before you continue, Madam Chairwoman, this is not reportable at this speed. It's far too fast and it's just far too dense. It's going to have to go half the speed if it's to be reported verbatim.
Well, I see some of my old friends smiling, going, as that Art can still move his lips.
You have to remember you're on Zoom and you're reading off a document at warp speeds because it's a little nerve-wracking. I know it is, but I just can't report it at this speed. If you can go about half the speed for the rest of the day, we can continue. I just am a little concerned I can't report it verbatim.
Okay, I promise I'll try to do a little slower in the future.
Perfect.
We'll all make an attempt to slow down. I probably am guilty myself. So we'll all try to slow down for the court reporter. Thank you.
And just so to finish this presentation, the county does not feel a need for a public hearing regarding this application. You can go ahead, please, to the next slide. Again, under the Watershed Protection Act, we recognize the higher relative priority over the CVP and SWP exporters, and the beneficiaries of the Watershed Protection Act are on equal footing. We acknowledge this equal footing of the other beneficiaries in 2008, and as Matt just explained, we recognize the priority system and what the Watershed Protection Act provides and doesn't provide to the county. But the most important thing is there's no time limit on exercising those rights. The next slide, please. Some protestants are relying on these water code provisions to indicate that the application should be canceled, or to support the notion that a hearing should be scheduled again to ask the question of cancellation. We don't feel that these code provisions have been met. We don't think that the standards set forth here have been triggered in this instance. As Matt explained, there's been quite a bit of work in developing this water resource in reliance on this water resource. And there hasn't been anything asked by the board that we have not responded to. In other words, there's no outstanding additional information request that has been ignored or delayed by any significant amount. We acknowledge there were certain time limits set forth in the amended application, and we haven't necessarily met each one of those criteria, but things have changed in that time period, especially with Sigma, as Matt's indicated, and a lot has gone on. So we don't believe there's a hearing needed, and don't believe there's any basis to cancel or revoke this application at this time. And that will end the presentation for San Joaquin County. Of course, we're all here to answer questions, etc. And we would, if feel necessary, have an opportunity to reply to any of the comments made by the protestants or to reply to any State Water Board staff.
Thank you very much. I appreciate that overview. I have a couple of questions in my notes that I'd like to ask while I have you, and then I will move to the other participants on the call to see if they have comments on this topic. The first one is sort of a housekeeping matter. I don't believe, and my team can correct me if I'm wrong, if I'm misremembering, but I don't believe in our records we have a protest, the records that have moved over to the AHO, which may be a subset of what the State Water Board has, but a record of the EB Mud protest. I didn't see that, which is why I didn't call it off on the list. I don't know that we have it, or at least I haven't seen it. If you would be willing and able to supply that, I think that would be helpful in any information about this 2014 agreement that is public and that can be shared. I think that would be quite helpful for my information to know. I would appreciate that.
There's no problem providing that agreement. There's nothing in there that indicates that it's confidential.
Thank you. I would appreciate that. The second question I had, I just wanted to ask in general, for my knowledge, whether the GSP, I was interested about the relationship of the GSP to this project. I realized some of those, I worked on Sigma, I realized some of those GSPs had more detail than others, but did this permit or this project, was that explicitly discussed in the GSP? Was it a specific management action that was addressed in the GSP as a tool to achieve sustainability, or was it sort of together with other general, the general concept of American River water and other sources and that kind of thing?
Neither it nor any of the other local water rights were articulated in terms of very specific water available for recharge, because the whole water rights discussion was kind of a third rail that would have gotten in the way of us meeting the deadline of getting that documented in January 20th. Again, I suppose maybe it's presumptuous, but we know we have filings on the McQuallamy. We know we have filings on the American. We know a lot of local entities have everything from pre-14 rights all the way through appropriative. There's a lot of riparian water. If anything, our options also make things complicated. If our water is American River, Calaveras, Stanislaus, and McQuallamy, all of those rights and entitlements are part of the dialogue, and it's ongoing in terms of what projects would use what water and how do we credit those entitlements and rights. To get into that level of detail and context of the GSP where it was not required would have slowed us down. It was one of those things that went in the parking lot along with like the absolute details on the funding. We know we need to resolve those issues. We know we need to come up with stable long-term funding for capital expenses and operations of any projects we build. And we were focused on the deadline and making sure we got what we believe to be a very adequate GSP in there. But it is not specifically articulated how we would use American River water rights in the GSP. It's more still that we know we need to do groundwater storage and banking and look at wet year and dry year types of operations and have operating criteria for the basin.
Thank you. That's helpful. And then just one more question, which I don't mean to bring us down a rabbit hole, but to the extent it can be answered, I'm curious as to why the county, to the extent either of you can speak to this, why the county's continued to pursue this application rather than withdrawing it and resubmitting when there's a more specific project, either now or in the past. I really was getting to the issue of water availability and priority. Does the priority difference between 1990 and today, is that expected to have a significant, or today or some future, shortly in the future, is that expected to have a significant impact on water availability? Is there a significant intervening filing that is of concern? I just wondered if you have any comments on why it is so significant to retain this application live rather than returning to the board at some future time when there's a more articulated project or there's better information. And I didn't know if there's something you could comment on that issue.
It's pretty simple. We wish and would love to say, you should have given us the water right we filed in the 50s. And then we know we would have had priority. But we're still maintaining the watershed of origin belief. And why would we give up a 1990 filing? Especially one that is under watershed protection, not subject to term 91, would be senior to, you ask yourself, why are these other entities protesting? Because they're on CVP contract water, and we would have priority and less subject to cutback. Why would we walk away from that level of certainty if indeed we feel it is truly a moral and a just decision to continue to perpetuate this application until it's timely for us to exercise that watershed of origin right with a 1990 filing. It would be folly to do otherwise. And it's very expensive to apply for a new water right or entitlement. It could cost up to $500,000 to do all of the analysis, all the engineering and hydrologic assessments to refile when we've been through it and we've spent thousands, if not hundreds of thousands of dollars trying to maintain this right, including paying $30,000 a year to maintain it. So we figure that $30,000 gives us some benefit and awareness and priority. And I mean, if you were to pull the water right, I'd ask for reimbursement for all the monies that have been spent to maintain this right that is now being taken away.
Yeah, I think that the simple response is it's much more financially and efficient and practically more efficient to continue versus starting all over again.
Okay, that's helpful. I mean, that's what I was trying to pin down. Is it a financial concern or is it a priority? Because in the grand scheme of water rights, as you know, a 1990 versus a today may not, on some systems really, it may not make a difference, which is why I asked the question. So that's—
I'd like to spend money trying to resolve the protests and establish the priority in context of what EID, El Dorado County Water Agency, and Sac County are maintaining.
Too fast, Matt.
Thank you for those responses. Those were my questions. What I'd like to do next is move. We'll try to do this in an orderly way. There are many of us, so and I do want to hear from you if you have substantive and important comments. That's certainly. But if it's in your status conference statement, no need to repeat it. I'm going to start with those participants who are generally in support of the application. Are there any comments that any of you would like to make with respect to this topic about the status of the application and the county's efforts to date and those issues? And you can feel free to put yourself off mute if you have any additional comments. And then I'm going to next move to the other participants. And we'll see if we can do this in an orderly way. And I appreciate your restraint on this so that we can move along. Are there any other participants today who would like to comment on this presentation, what the county has said, realizing we're not making substantive decisions on the county's application today? This is not the time or place for that, but just on the process going forward.
I'm not sure if now would be the right time, but we don't technically have the protest filed on behalf of Woodland and Davis, Clean Water Agency, City of Folsom, City of Roseville, and Sacramento Suburban Water District. So at that time, I believe we would set forth all the reasons why we are involved. But if you'd like some information now, I can discuss it.
No, I think I appreciate your comments on the position of those entities. And I think at this time, this is fine. If and when we get to the point of holding a hearing, then having more information may be appropriate. But for purposes of the status conference, I think we have the information we need. Thank you. I am going to move to item 4, which is this issue of whether the AHO should schedule a hearing. I know we've heard from the county, although I'll invite you, if you have further comments, to make those comments. The question is whether the AHO should schedule a hearing to consider, and bear with me, I'm going to talk for a little bit. I will try to slow down. I do have a script that I'm reading from, so I don't miss anything. Whether the AHO should schedule a hearing to consider whether the board should cancel, reject, or deny the application under Water Code sections 1276 or 1335, or California Code of Regulations Title 23, Section 683 or 840. And I wanted to add to that question, bear with me, please. It will be a multi-part question. I also wanted to ask whether the AHO should schedule a hearing to consider whether the board should adopt an order setting some sort of time schedule for the county to complete milestones and submit information necessary for the board to consider the application on the merits. If the AHO does schedule a hearing, when should that hearing be held? Or should the AHO take some other action, which I think is what most of you seem to suggest in your status conference statements? If you're proposing some other action, what I'd really like to hear from is about how we would proceed if it is without a hearing, because that was the suggestion in the status conference statements, and those were for different reasons based on whether the party supported or opposed the application. But I want to understand exactly how you would envision how we would proceed without a hearing, given that the matter is now assigned to the Administrative Hearings Office by the board. And the AHO does have a pretty specific role as defined by the statute and what we generally do for the board. Once again, I've read all of your statements, so this is an opportunity to add to what you've already submitted. And I'm going to start with the county, Ms. Brenner, and then we'll move to the other parties in support, generally in support, and then we'll move to comments by those who are opposed to the application. And if we need to, if we have a lot of people who want to comment on it, I'll move through the list as we called appearances. So that will generally be the order. Ms. Brenner, do you have any comments on this?
Yes, just briefly. The county believes again that there's no need to schedule a hearing for cancellation, revocation of the application due to the fact that we've established due diligence in pursuit of this application. And that's in light of watershed protection laws, SIGMA, the overdraft conditions, et cetera, that we're working with, and the regional approach that the county has been developing. So those things need to be taken into consideration with regard to the next steps. We feel if there's a need for any kind of follow-up on this application, that it should be at 18 to 24 months out, and that it should be as more of develop a schedule for check-in periods for the county in the pursuit of their application, their continued pursuit of their application.
And maybe on that point, if I may ask, following up on the last, I think that the last record that the board and the division files has of a time schedule was the schedule proposed with the 2014 fourth amended application. And it at least appears to me from the bar charts, we're well beyond that schedule. Is the county intending to submit anything that would clarify where we are and what the proposal is? Or is that not ascertainable at this time?
We feel like we could put together a pretty solid schedule if you provide us 18 to 24 months out to take certain steps with outstanding partners and some other efforts that we have in mind during that time period, that we could come back with a schedule that's meaningful.
So the schedule would be, we would receive the schedule in 18 to 24 months.
Correct.
Understood.
I think anything prior to that would be, we need more time.
Thank you. And the other participants in support of the application, would you like to comment on this issue? Hearing none, I'm going to move and we'll see if we can do this in an orderly way. To others who are in opposition to the application, are those who would care to comment on this issue? Mr. Stork, I see a hand.
Sure.
Thank you.
Let me just make some quick observations. The application is being made for an American River application, and yet the project is being proposed on the Sacramento River. It is true that the watershed protection statutes are not limited, and that the actions of the projects shall not deprive the downstream folks of water needed for their development. But water rights applications are not in that context. There's a certain amount of diligence that's required, and so it's your questions about that you had earlier, I think are rather significant. And I think if we go to hearing with the county continuing to say that we need to keep our application going for the indefinite future. Those are questions that should result essentially in a dismissal of the application and a suggestion that the county come back when it's ready to actually pursue one.
Thank you. Are there other comments from any of the participants? You may. Ms. Johnson, I see a hand, a non-Zoom hand. Thank you.
As we said in our status conference report, we do think that this application can be canceled without a hearing. Code 1276, 1335, and Code of Regulations, Title 23, 683. But if the office is not inclined to do that, we think there at least should be a hearing on cancellation rather than moving forward without. This application was canceled once prior. There are 4 areas that were noted by the Department of Water Rights at that time for doing so. 3 were noted on your notice of status conference. The additional being, a lack of analysis of available water. And all 4 of those areas continue to be outstanding. With regard to the Watershed Protection Act, and substantively, we didn't read the notice as putting that at issue today, but the applicant has raised that obviously extensively, arguing that they should be given more lenience to take their time on this application for that reason. But really, the Watershed Protection Act has to do with priority. It doesn't change the requirements for applying for and vesting a water right. And so we don't see any reason why they should be allowed to, pursue this without diligence. Even from the presentation, we don't see any project-specific activities that have taken place since 2014. Further, the county is saying they're not ready for a check-in for the next 18 to 24 months. So we do feel it's more appropriate for them to either cancel or withdraw this application and apply when they have more detail on the project they plan to pursue.
Thank you. Are there other comments? Mr. Schutz.
Thank you very much. Similar to Ms. Johnson, I didn't really understand the argument that the Watershed Protection Act absolves the applicant of the need to diligently pursue its application. That seems to be the gist of the argument. And if it were a matter of applying for assignment of a state filing, that would be different, but I don't see that as being something that's in play here. As regards the assertions that certain things have been accomplished in the interim 7 years and in times before that, it seems that they're all rather incidental to the application and not specific to it. And that seems to me to be an important element for the hearing officer to consider. There remain really fundamental problems with this application. There's no funding. There's no indication that they've achieved any agreement for the use of the facilities that are essential to it, either from the Freeport Authority or from the Bureau of Reclamation. And I understand that having achieved an agreement of sorts with East Bay Mud is an important step, but there are 2 other major steps that not only don't seem to have been resolved, but don't really seem to have even been addressed. So having achieved certain milestones sort of along the way without directly having sought to do it in aid of this application doesn't seem to me to qualify as something that would merit diligence. This is a 30-year-old application, and having been in the business for only 20, I'm concerned that, and not knowing how much longer I'll be in the business, I'm concerned that these lingering applications just keep going and going and going without any substantive resolution. So I think I'll stop there. Thanks.
Thank you. Are there other comments? Ms. Jacobson?
Yeah, it's just unclear to me if we were to go forward with just an 18 to 24 month check-in status, when and if the 4 clients of mine would be able to protest if you're going to open up the protest period. And so I would just want that clarification.
Understood. Thank you. Ms. Ackroyd?
Yes, I don't want to repeat what's already been said, but would just note that I would agree with the statements that were already made by Ms. Johnson and Mr. Schutz in respect to just echoing again that there can be cancellation, and that the pursuit or the events that have occurred in the last several years don't seem to rise to the level of pursuing the application or meeting the deadlines that were previously set or proposed in 2014.
Thank you. Are there other comments? Ms. Sagatellia, did I pronounce that correctly or close?
It's Sagatellian from Westlands Water District. Thanks. I just wanted to say I don't have a lot to add to the protest and to the Westlands Water District's previous position, but we just saw the PowerPoint late last night, and we haven't really had an opportunity to digest everything that has been said. And this is sort of coming along the lines of a almost contested hearing today. I know you said that you aren't prepared to issue any type of decision, but I think we're kind of at a disadvantage in digesting all of the information that's been presented. So all I want to say is if there is an idea to continue the status conference, we would support that, just so we have a little bit of additional time to, if we're going to take issue with the previous points or not. And I'm not saying we are, I'm just saying it would be fair to give us some more time to take a look at all of it.
Thank you, understood. And I recognize, you know, the PowerPoint was circulated late. I think it was helpful, and I appreciate it, and given the circumstances and the procedural nature that it's appropriate. But I take your point under consideration and take it to heart that depending on where things go and the outcome of this, that it may be appropriate to for all of the parties to have an opportunity to present more information and to be heard. So thank you. Are there other comments? Mr. Schutz.
Sorry, I forgot to mention, I didn't believe that it would be appropriate to cancel the application without a hearing. My understanding was that that's normal procedure. Although it may not be allowed, it seems that we sort of did this once before. There was a cancellation. The county asked for a hearing, and as I recall, there was one. And it seems like they would ask for a hearing in any event. I do think parties should be given enough time to prepare for a hearing. And since this is a lot of old information, it's going to take a lot of review by a lot of different folks, it shouldn't be right away. But it shouldn't, in my opinion, be deferred for too long. The county deserves an answer, and the folks here have been looking at this for an awfully long time, and sometime this summer might be an appropriate timeline. Thanks.
Thank you for that. I'm going to take I am going to ask the county if they'd like to respond, but first I'll take a last call on additional comments. Seeing none, Ms. Brenner, would you like to respond to anything?
I'd just like to reiterate, and clarify, it was a water availability analysis performed, and it's current, it's being utilized. Also other technical examinations, assessments that do look specifically, are looking specifically at both the McCollum and this American River application and the utilization of that water supply, including what Matt went through was the feasibility analysis that is specific. It is specific to these water right applications. And again, what are the opportunities and the different types of projects that could be implemented that would utilize this water right application? So there has been very precise analysis. Go ahead, Matt.
You know, and to the point that this is, you know, a 30-year-old application, realize this is a 60-year-old ordeal for the county in terms of getting jacked around, moved around, pushed to the American River, pushed from the Folsom South Canal, a least cost alternative for taking the water down to the Freeport, which has a higher cost, which certainly delays or limits or puts constraints, say, on action. So you might think 30 years, we're thinking 50 years. And we're thinking this should have been the water rights application that we did put in that was denied in the 50s.
Point of clarification, since I have you, the water availability analysis is that I'm looking at our records that we have, that the AHO has, again, that may not reflect everything. It looks like the 2012 is the 2012 WAA. Is that the most recent and up-to-date version that you're referencing?
No, is that the Chuck Hansen analysis, or is that the water availability analysis that was in the Freeport document? Because that is the one that is probably the most contemporary and the most accurate in terms of fully evaluating the constraints to diversion at the Freeport point of diversion. And again, you know, it didn't go into the whole, well, gosh, compare that to the use of the McCollum. And we just have not continued to pursue, because again, we were pushed to the Freeport project from the use of the Folsom South Canal.
So maybe may I ask Ms. Brenner and Mr. Zaidar, your team, to take a look at our FTP site. We have all of the documents that the AHO has in our administrative record for this matter is up on our FTP site, which is password protected, but you can obtain the password from our team by emailing our office, and just check and make sure that we have this most updated version somewhere in our files, or if we don't, if you could just please submit it. I think that would be very helpful. I'd appreciate that.
Yes, we've looked at that site and we will do that. We'll update it.
Thank you. Are there any, my last item on the list here for today, I think we're wrapping up. I really appreciate how far we've come. Are there any other procedural items that anyone would like to raise at this point? I'll caveat that and say, my plan for the next steps is to take all of this under consideration, and then in a few weeks, 2 or 3, issue a ruling letter of some kind, laying out where it is we're going to go, whether that's another status conference to reconvene, if I have additional questions, if we want to discuss certain issues further, whether it's laying out a hearing notice, whether it's moving forward with some kind of time schedule, milestones, or setting out a status conference far into the future. We talked about a number of possibilities today. So my plan is to send out a ruling letter in a few weeks, but are there any other items that anyone would like to raise before we adjourn for the day? Seeing none, thank you. Thank you very much for your input, for your time. I know there are many of you here, and it was very helpful to reconvene on this and revisit. Mr. Zaidar, I saw a quick hand. You're on mute, though.
What is the timing for your action And what is the outcome?
Well, that's what it hasn't been decided. A ruling letter would lay out what the AHO sees as the next steps. Now, keep in mind, under the AHO's procedural statutory authority, we issue proposed orders. So if the board were to take some kind of final action, that wouldn't come directly from us. It would be a proposed order. Typically, a proposed order would come after a hearing. That's our normal process. We hold a hearing about whatever the issue is, draft a proposed order for the board, and then the board considers that proposed order. So that would be the normal outcome if we were to issue or recommend that the board issue some kind of final order. Typically, that would come after a hearing. Now, if the determination is that a hearing isn't not appropriate time for a hearing, then we may defer out and set future status conferences or set a schedule of some kind as to how we're going to proceed forward. Does that answer your question? Well enough. Thank you. Any other comments or questions at this time? Well, thank you again. You can expect to see that ruling letter fairly quickly. Thank you for your participation, and I'm going to call the status conference adjourned for the day. Thank you very much. Have a good day.
Thank you very much.
Thank you very much.
Thank you.